State versus King, 15-1-200-2 for the defense motion hearing. I've read through the documents and I'm fairly familiar with the case. So,
Judge, just to start out with, to confirm what Mr. Roberts had said in his most recent reply, the state is moving to dismiss counts 2 and 4. Count 3, we had orally said that we would dismiss at an earlier hearing. I'm handing forward a motion to dismiss counts 2, 3, and 4. I don't expect the court to read this at this particular time. It just sets forth the rationale that I had in my mind for why dismissal was appropriate. I'm also handing up an order dismissing counts 2, 3, and 4, which counsel has signed off on dismissing charges without prejudice, although the likelihood of this ever being refiled is slim.
Mr. Roberts.
Judge, I'll try to be brief in recognition of the late hour and the court's needs here for this afternoon, I'm sure, but I'll tell you that this case is tricky because we have an affiant or a declarant who's a non-law enforcement officer. That is a person with a dog in a fight. An alleged victim is the declarant in this case, and so it's hard to put a knapsack before the court and say that there's under 8.3c the court should dismiss, because that would require us admitting the truth of the declarant's statements in that initial declaration for probable cause. And that's why I brought up this res judicata argument before the court, because I think that if the court were to examine, or I'm sure it has, examined the civil ruling regarding Ms. Shoemaker's case against Frank Euro and Laura King, the court will find that Ms. Shoemaker is bound by a civil judgment saying that, number one, she didn't have exclusive property rights in that digital art library, and that she obtained non-exclusive usage rights for purposes of the direct-to-garment business. That was the property right she obtained when she entered into the contract with Mr. Euro. That right is not a right of exclusive possession, and therefore the evidence that the state submitted, that is Laura King's email saying that she's taken a copy of the digital art library in trust to protect it for the true owner, is not the appropriation of property of another with the intent to deprive the true owner thereof. There's no question that at the time that she indicated she had a copy of the art library, there was a question as to ownership. Sally Shoemaker had shuttered the business in December and had stopped making payments, and then next thing you knew, she had abandoned the business and tried to rescind the contract. So at that time, Laura King, who has a copyright interest and a restricted or non-exclusive ownership interest in the art library that vested upon its creation along with her daughter Samara, who's in the gallery right now. When Samara King and Laura King created those images, they acquired a copyright. That copyright, if the court reviewed any of the trial testimony, was almost valueless in the sense that they couldn't use that art library to compete with the direct-to-garment printing business, because those rights were sold to Mr. Euro and then sold to Ms. Shoemaker. So Laura King and Samara King had a reversionary interest, as she described, and they asserted that ownership. Laura did in keeping it in trust to protect it from being damaged, destroyed, or deleted, because it's not a physical thing, Judge. It's bits and bytes, ones and zeros stored on computer disks or solid-state thumb drives. That data was something Laura preserved and protected, and she's admitted as much. To say that she stole something that she had a copyright and a limited ownership interest in is not stealing the property of another. I'm looking at State v. Lau, 174 Washington App 857. It says the meaning of property of another is derived from the definition of owner. The definition of owner, quote, establishes the level of interest necessary to claim a right to property. So Sally Shoemaker had a right to property, but Laura King also had a right to property. For Laura King to steal property from Sally Shoemaker, it would require her to use that property right against the right of the true owner. In other words, Laura's possession of it was not theft. If Laura had turned around and used that digital art library to print and sell garments at the time when Sally Shoemaker was doing it, then she might have been stealing intellectual property, because Sally Shoemaker at the time had the right to use it to do that. So I'm in a position where I can't do a Napstead argument. Judge. All I can do is ask the court to recognize there was a civil judgment, a binding order that went to finality, and for the state to prosecute Laura King for theft, they're collaterally attacking it because they're trying to realign the bundle of sticks that we all learn about in law school. Mr. Haas's argument, Mr. Haas's charge, essentially says Sally Shoemaker had the whole bundles of sticks. She could exclude anybody, and that's just simply not the case. Laura King's possession of the digital manifestation of that art library isn't theft, and it's not against the property, the right of the true owner. But the most simple way for us to get out of this, Judge, is really simply put, the state hasn't given us a bill of particulars yet. We moved for a bill of particulars several weeks ago, and still we have a charging document that says specialized computer equipment and proprietary software used in the direct garment printing business. I can't defend against that. I have my own suspicion about what that means from interviewing Frank Euro, and in my reply you'll see that he mentions that his understanding of specialized software is a laptop, or a computer is a laptop, and the specialized software, Judge, is a driver you can download for free off the internet and a $40 copy of an old Photoshop software that he got off Craigslist. That's his understanding of what software was needed to transfer this equipment, but the state's charging document is alleging that there is specialized software and proprietary software and specialized computer equipment that Laura King has stolen. So I'm going to ask the court to dismiss without prejudice just because we don't have a bill of particulars yet, and we've pushed the trial date back and back. And so I don't think that information is coming because I don't think the state has it, and so I'm going to ask you to dismiss on those grounds. But when the court decides whether this civil verdict is binding on anybody, you may not find it's binding on the state. And I understand that Mr. Haas's argument that the state can prosecute people without regard for civil judgments it's not a party to. But that doesn't quite work, and it's not purely true. For instance, Judge, just hypothetically speaking, if I were a person, an adverse possessor of property, I stayed on the property open notoriously for 7 years and acquired title, and this court said Mr. Roberts acquired title because of adverse possession, the person against who I gained that title right couldn't turn around and have the Jefferson County prosecutor prosecute me for trespassing, being in that property, because I acquired that title by operation of the law. In that case, a civil judgment, Your Honor, would bar or stop the state from claiming that my conduct was illegal. And in this case, this court itself, not Your Honor obviously, but this court itself sat during a civil trial where there was a discussion about facts related to a contract that was executed and Ms. King's involvement in it and Ms. Shoemaker's involvement in it. And it was adjudicated after full and fair hearing that she wasn't defrauded, she being Sally Shoemaker, that she obtained all the rights she had and that her rights to the art library were non-exclusive use rights only for purposes of the direct-to-garment industry, not her right to exclude everybody else from possessing it. And the notion that there's a one single unique copy of the art library just isn't supported by the evidence. It's digital media that can be stored in any format. It can be copied, reproduced, and it would be an issue about who had the right to use that. We know for a fact that a woman named Giovanna has her own copy of it that she uses for selling hard goods and printed images to the aquarium industry. Frank Euro knows about that too, because when he obtained the rights, it included that woman's pre-existing rights. So Judge, when you're asking whether this case is identical to the original civil action, you look at that four-part test from the Ninth Circuit case, Chow v. Chow 1. Did you see that in the reply? Ms. King got a judgment that she wasn't a proper party to this contract after having attorneys represent her in litigating this, and out of the same transaction nucleus facts, the infringement of the same right, that is Sally Shoemaker's alleged ownership rights, and exactly the same evidence, she's now been deprived of the benefit of that verdict or that ruling because she's here in a case about the same thing. So I'm going to ask the court for two reasons. First and foremost, because the state hasn't provided a bill of particulars, I'm going to ask you to dismiss without prejudice for that reason. It doesn't impair their right to proceed if they decide to do that. If they had to get the evidence and the information to bring a complete charging instrument in front of Ms. King, they can do that. They've had plenty of time to provide the bill of particulars. Dismiss without prejudice because of that. But dismiss without prejudice because it's an improper collateral attack upon a civil judgment that limited to Ms. Shoemaker's rights. And as the state's only affiant, regarding these events, she shouldn't be able to lawfully go before this court and testify in contradiction to a civil verdict where she's bound by it. So it's weird mental gymnastics, Judge, and I don't know how to make it any cleaner for you, but the rights were adjudicated. And her belief, in this court's own words, that she had exclusive rights to possess the art library for something other than its use in digital printing was, at best, an unreasonable unilateral mistake on her part. That's Judge Wood's ruling. She didn't get those rights that she thinks she did, and that's the basis for their claim.
Okay. Mr. Haas?
Thank you, Your Honor. I think that counsel and I would both agree that this case certainly requires a number of mental gymnastics. With respect to the bill of particulars, we have provided the defense that information that we have, so we are not able to provide any more information beyond that which they already have. The bigger question in my mind is wrestling with this notion of the civil trial and then the tie-in to the criminal matter. There is, I think that the analogy that Mr. Roberts came up with within the last few days about the adverse possessor of property, I think that creates a significant issue for the state. I wouldn't say that this has to be dismissed based on that, but it certainly, I'm trying to sort of imagine if I was on the bench right now what I would be doing, and I would be troubled because certainly I would want finality of judgments. I would want the civil decisions that this court made respected by all parties. And certainly if I had a case that came to me, such as Mr. Roberts describes, where he has adversely possessed Blackacre, and to use a term from law school, and the person that he adversely possessed the land from then seeks redress in the criminal courts because Mr. Roberts is now trespassing on Blackacre, at least from the other party's perception. That does create a real problem, quite frankly. I don't think that I had analyzed this decision in that particular case. My brief, the state's brief, obviously addresses collateral estoppel, res judicata, those types of issues, and I don't need to go over that. I know Your Honor's pretty thorough about reading through the briefing. So, on some level, without trying to torpedo my own case, I understand where Mr. Roberts is coming from. I'm not sure. It's certainly, obviously the state was not a party to, would not have been a party to the Blackacre litigation, for example. We weren't a party to the underlying litigation here. Would things have been different if the state was involved? Yes, but do we want the state to come in and be involved in every piece of civil litigation that occurs in this court? Good Lord, no. We don't have the resources, and the parties certainly don't want us involved in it. About as close as we get to that is some of the support enforcement work that we do. At the end of the day, I think that this is probably more of a policy decision than a legal decision. Or it has a blend of both. And I'm not trying to muddy the waters, Judge. I'm just trying to, this is, I think that this is a much more complex issue than certainly I had anticipated when we filed the charges. I think I'm just going to be quiet and ask if the court has any questions.
I think one, let me, in here somewhere, and I can't put my finger on, I'm not gonna try to put my finger on it, but, okay, Mr. Roberts is arguing that a civil court has determined ownership of these, of this intellectual property, of these inchoate rights to use this artwork. So basically he's saying the civil court, Judge Wood, ruled that Shoemaker only had a non-exclusive right to use this stuff, which would also mean then that other people have some kind of non-exclusive right to use it. Does the state agree with that?
That is definitely Judge Wood's ruling, as I understand it. That is correct.
Okay.
I think where we got hung up, Judge, is within the memo that shows up where the defendant indicates, I'm taking this property. The effect of the word entrust, I think, again, that has sort of, within the trial, there's testimony that the defendant didn't have a right to possess it, the property, but then there is this residual non-exclusive property right. So I wish I could help you more, Judge.
I think I can shed some light on this. See, what's really critical to understand is Laura King and Frank Euro were in this business before Sally Shoemaker got involved. And so Laura King and Samara King created this digital art library from sketches. I didn't bring one because it wasn't an exhibit. I didn't want to turn it in, so I didn't want to introduce it as evidence. But these are rough sketches. They're beautifully done, but they're not something that's of any value. Through her diligence and work with Photoshop, they turn it into something you can sell, but it's all for purposes of printing onto garments or other things. And so nobody who operates in that business says they have the right to sell the library to anybody else or to use it for commercials or other things. It's just created for the sole purpose of putting it on a shirt print, like I showed you in one of the exhibits in my reply. So when Laura says in her testimony that I didn't have any right to the art library, what she meant is I didn't have a right to use it in the direct-to-garment industry, which is what was being sold between Frank Euro and Sally Shoemaker. And so when you
could have used it maybe to, for example, print things on dishes.
Right,
or,
right.
Or on, on some other substances
Exactly.
other than garments.
And in this particular instance, subject only to the rights of the other person, Giovanna, who had some rights to use that art library to sell some hard goods like dishes,
Right,
whatever,
okay.
to aquariums. So people were speaking in shorthand because when you're in the industry, as the court knows, like we have jargon in the law that's very, very Byzantine for outside people. The jargon in this sort of industry was Byzantine for someone who doesn't get involved in it. In other words, you think of rights, we think of the whole bundle of sticks. But no, she was speaking about, I don't have a right to the art library because I can't use it in this industry. But she certainly can have it on a computer at home and tinker around with it because she and Samara created it. And that's what's even recognized in all the documents Mr. Haas has filed. They created, they have a copyright that was vested during their collaborative work process, and Frank Euro, as the owner of a business at the time, may be able to assert some sort of corporate ownership of it because they were working with him and for him at that time. But that's between those guys. Right now, Sally Shoemaker's bundle of sticks is pretty small. It's, yeah, I can use this in the direct-to-garment industry, and I think that Mr. Haas acknowledges, and the court should acknowledge, that we're talking about the infringement of her being Sally Shoemaker's rights and whether that can sustain a conviction for theft. I think as a matter of law, it can't.
What document in the stack of stuff, I can't remember what document is it, where it basically Judge Wood said that it's that Shoemaker has a non-exclusive.
Findings of fact, conclusions of law as to Frank Euro. It's going to be Exhibit A to my initial brief. The initial motion I filed, Judge, I'll give you.
I've got it right here, Judge.
Yeah, here, I'll just hand it up. Judge, if you don't have it handy, you can just take this copy and look at it. I think you might
No,
find it.
I have it
Okay,
right here.
yeah,
What-
so if you
what
look at that,
section?
Judge, you're going to find item on the second page of those findings of fact, conclusions of law.
Yeah.
Or no, third, pardon me, third. Oh, I'm looking at Exhibit A, I mean Exhibit B, I'm sorry. We're looking at Exhibit B, Judge?
B is the one I should be looking at?
Yes,
Okay,
because
go
it's got a
ahead.
bunch of handwriting on the third page. Judge Wood did some
Okay.
pretty deliberate editing of that. You'll see that
Where is
paragraph 4.6,
Okay,
plaintiff received and had possession of the non-exclusive use of the digital art library developed by Laura King and to be used in connection with Orsacopia DTG, standing for direct to garment business. Contract did not convey to plaintiff the exclusive ownership of the art library. She had the yeah. So that's what we're talking about. And so theft requires property of another, and I don't think that the state can meet that statutory requirement without averring that the civil ruling was wrong, or averring that Laura King used or possessed the art library in a way that interfered with Sally Shoemaker's right to use it. And there's no evidence in the declaration that she printed garments or sold anything and competed with her. That would be theft in that case, because that would have been a use of it in violation of Sally Shoemaker's rights.
did Shoemaker still have a copy of it by which she could have printed T-shirts or something?
I don't know,
the declaration.
I don't know whether she did or not. I can't say that for sure.
So anything I say is-
It could have fit on a thumb drive,
Yeah.
obviously.
Right.
But I don't know that Ms. Shoemaker actually had that. One of the things that ties into this also, and one of the things I raised in my brief, is the issue of the bankruptcy. And I think that in meeting with, I don't know, we spent what, hour and a half last week trying to sort this out. And the bankruptcy issue is not as damning as I thought it was. And I'll let Mr. Roberts explain why that's the case, because I think he can articulate it better. But one of the concerns that we had is that Ms. King couldn't take this, she couldn't have any ownership interest in it because just a few months earlier she claimed in bankruptcy that she didn't own any copyright or any intellectual property. And again, I'm going to defer to Mr. Roberts to explain why that is not as relevant as I thought it was. His explanation made complete sense to me. I'm not sure I can repeat it exactly.
I'm going to take you right back to the finding of fact conclusions of law. The first sentence, plaintiff received and had possession, okay, of the non-exclusive rights. Judge Wood ruled that she got everything she was supposed to get. And 4.7, plaintiff failed to prove that she did not receive any other assets to which she was entitled. So if the civil judgment was about, yeah, you had these rights, but you haven't been delivered to you, that wouldn't be the ruling. What this ruling says, Judge, is that not only was her bundle of sticks the non-exclusive right to use, but it was delivered and she had possession of it, okay? Because there's no dispute, and Mr. Haas knows, that business was open for a while before it was shuttered. And so Sally Shoemaker's not claiming she didn't have the art library then to use it. This is purely a complaint about Laura King's possession of it, not her interference with non-exclusive usage rights or anything like that. And I think that as we get through this, we're realizing that we're collaterally attacking the civil judgment. And Mr. Haas's discussion of bankruptcy, I know what he's getting at, and I'll tell you, Judge, that the testimony of the civil trial, one of the experts that Mr. Haas listed as a potential witness to his was that the digital art library itself is relatively valueless when someone else has exclusive usage rights, especially in the industry that it's really intended to be used. You might be able to make some cool plates and other stuff, but that library was really about making T-shirts. And the kind of the media that they used, that Samara used to create the original documents, is color pencil and a lot of stuff, so it's fuzzier lines and things which aren't as good for printing on hard goods. This was really about printing on shirts. And so when Laura King couldn't use it to print on shirts, it was relatively valueless, which is why she disclosed in her bankruptcy, no, I don't have anything. She skipped past the, yes, I have it, and it's of no value. She said, I don't have anything of value, and it was just a mistake. It wasn't perjury, it was an error.
So if she had a non-exclusive right to this artwork and as Judge Wood found, et cetera, there in that language, okay, so that takes, if I go with that, similar to your adverse possession analogy, there might not be any theft there in connection with that artwork. What about the specialized computer equipment and proprietary software?
So that's great. And I think that's, my whole point was, Judge, that's what you're left with.
The bill of particulars?
Right, and so because if the court accepts Mr. Haas's polite and articulate concessions and my vehemence about this position, then yeah, you're left with looking at theft one about specialized computer equipment and proprietary software. That's all that's left. And that's impermissibly vague under Leach and that standard. And as Mr. Haas indicates, we poured through the discovery. There's nothing provided by Ms. Shoemaker to the state, or now the state to me after my request for a bill of particulars, to clear that up. So I'd ask you to dismiss it without prejudice on the basis that it's vague from a due process standpoint. When Mr. Haas gets the right information, if he ever does, he can refile it. But I can tell you what he's going to find. He's going to find out that Frank Euro had $40 worth of used Photoshop software and free downloadable print drivers on a laptop that no one can locate. But certainly not a laptop that Laura King needed or possessed. So,
And Mr. Haas, your response on that issue, if any?
Yeah, he's correct. I mean, I don't have any other information.
Okay.
I think when I filed the charge, I was making the assumption on some level that you couldn't just hit print and it would just miraculously appear on a T-shirt, for example, or on a coffee mug. And so I may have misperceived that. I have no other information though on that to buttress the bill of particulars.
Okay, well, here, based on everything I've heard, like I said, I read through all this stuff. I think ultimately, I think the analogy to adverse possession is exactly right, because if it's determined, if somebody's determined to be the owner of property, and whether it be, I guess, really by a deed or contract or by a court decision or whatever, but in this case by a court decision, then, and like by adverse possession or some other theory concerning real estate, then that person owns that property and can't be charged or prosecuted effectively with trespassing or anything like that, because the court order says they are the owner. And here, based on Judge Wood's findings and decision in the civil trial, it appears to me that it's essentially or substantially an identical situation. And Ms. Shoemaker had what she purchased. She had a non-exclusive right, and that meant that other people had non-exclusive rights. And there isn't any evidence that the defendant in this case violated the non-exclusive rights that Ms. Shoemaker had. So on that basis, I would grant the motion to dismiss the theft as it relates to the artwork, and as far as how it relates to the quote specialized computer equipment and proprietary software, end quote, I would grant the motion to dismiss without prejudice on that. My first decision is with prejudice. On this, I dismiss it without prejudice for lack of a bill of particulars, because it really hasn't been specified what that specialized computer equipment or proprietary software is, other than what I've read here, which doesn't adequately describe it. Anyway, that would be my decision. Does that cover?
it does,
I
Judge.
think it does, Chair.
What we're doing today?
I'll get together with
Yeah.
Mr. Haas and prepare an order for the court.
Right. Yeah, if we can hand that up to you off record.
Yeah, that'd be fine.
And, I think both parties really appreciate the work you put into this, because this is not a typical criminal case.
There was a lot of work put into it by people, so.
Yes.
Okay, thank you.
Thank you.
All right, thanks,
All
Judge.
set. Okay.
Thanks. So let's walk out here. We can wait.